or a reality? On the panel, we have Mr. Dhirendra Negi, partner at JSA Advocates and Solicitors, Mr. Stephen Lim, arbitrator and barrister at 39SX Chambers, Mr. Zal Andhyarujina, senior counsel, and Ms. Clara, Tung, managing associate at Linklaters.
Good afternoon, everybody. Can you please all settle down so that we can start early? Otherwise, Neeti has given an open threat that she will close the session and we'll have nothing to talk about. So thank you so much. If you could kindly have your seats, please. So we have start, please?
Yes.
Okay. Thank you. Good afternoon, everybody. And hope everybody had a nice lunch and you're all full of energy and expecting that nobody's feeling sleepy now after the great lunch. But anyway, moving forward, the topic of this session is arbitration, a one-stop forum. Is it an illusion or a reality? Now, how did we get to this topic? It was in 2007 when the English Court of Appeal used the expression that there is a presumption in favor of one-stop arbitration. Now, this was a case relating to bribery, and a stay was sought on a civil action brought by one of the parties. Few years down the line, our own Supreme Court of India, in 2016, if I'm not wrong, echoed the same sentiment and said that arbitration should be one-stop forum. And in fact, may I just quote that line? The Supreme Court said the duty of the court is to impart to that commercial understanding, that means a one-stop forum, a sense of business efficacy. Now, from 2007 to 2016, and we are now in 2023, so we thought it's time for some reality check, whether arbitration is serving the purpose and whether this arbitration, a one-stop forum, is it really something which is there in reality, and is it something that what the parties want and what the arbitration community is giving to them? If I am a businessman, let me put myself in a businessman's shoes. He enters into a deal, there's a transaction, and in the end is a boilerplate, usually a boilerplate clause, saying that if the disputes arise, then we will go to arbitration instead of going to the courts. Now the question is why? Because I have been told by the legal community, the arbitration community, and many others, that arbitration is far superior than taking your disputes to the court. It's cost effective, it is timely, and the award which is passed is binding, and very seldom that the courts interfere with the awards. But when I, as a business person, go to arbitration and try to invoke that remedy, it's not that simple, and we all know it. Starting from the point of the constitution of tribunal, the time that is taken in the arbitration procedure becoming a mirror of court proceedings, and ultimately the question of enforcement. And there are many such issues which which arise. And then one wonders that is it really worth it? Is arbitration really worth it? So to cut short this introduction, we, our esteemed panelists here, are going to discuss some of the points concerning this topic, and then ultimately we'll sum up as to whether arbitration is really a one-shop forum and is a convenient forum to the satisfaction of the clients. Unfortunately, we had one of the panelists as a client, and I personally wanted him to speak, take his views, but unfortunately, for some reason, he could not make it to this panel. But anyway, the panel that we have today needs no introduction, but as a matter of courtesy, I will start with a lady, Clara Tung. Clara Tung is with the Linklater's, and she is a young, bright, and lawyer, and she focuses on energy and technology sectors. I hope you didn't mind calling you young, right? That's right. She's currently in London, but she does her practice in Singapore, UK, and India, and she has done a lot of arbitrations under all institutional as well as ad hoc arbitrations, and has worked as law clerk with the Supreme Court of Singapore, where she clerked with Justices of Appeal and current and former Chief Justices of Singapore. Sitting to the right of Clara is Zal, and Zal needs no introduction. I mean, you know, whatever I say would be less, so I'll skip it and and next to Zal is, of course, Stephen Lim. Stephen Lim, as you all know, is a barrister and is an arbitrator. He has done so many arbitrations. And when I looked at his CV, I said, oh my God, like how can a person have so many arbitrations and so much of experience? But I think it was a good choice. Thank you so much, Stephen, for being here. I think we have some learnings from you, from your experiences, especially your experiences. You know, arbitration for the practitioners as also for the arbitrators is all about experience. And because law is always there, but arbitration has its own world. So that's so much for the introduction. And we hope to finish within an hour, or maybe even earlier. And let's start going on this. Zal, I'll start with you, okay? Now, this is in the context of, mostly from the point of Indian arbitration universe, where predominantly, till date, we have, you know, a penchant for ad hoc arbitrations. I understand that the winds of change are blowing and we are progressively moving towards institutional arbitration, but not really that so much. And given the fact that we don't know when the new amendments, 2019 amendments concerning the appointments will come into effect, let's assume that they are here. I mean, Section 11 as it stands is here and it's going to be there for a long time to come. So before a person even, you know, invokes the arbitration, or at the time when he invokes the remedy of arbitration, the first hurdle in the Indian context is regarding the constitution of the tribunal. I give a notice of arbitration, other party for some reason or the other doesn't appoint as arbitrator, and so I have no other remedy but to go to the courts. Now, I as a party would expect that I'll show the court the arbitration agreement, and the court would immediately appoint an arbitrator so that my arbitration starts early. When it will finish is a different matter, but at least it will start early. In that context, I will take you, and probably a lot of people here would be familiar with the judgment of Vidya Drolia, and we'll take a pause from at that point in time of the development of arbitration in India. The court said that normally all the disputes, all the questions regarding the existence, validity, etc. must go to the tribunal, except for certain circumstances which are there in the judgment. Now, I'm not going to so much into the correctness or whatever, everybody has their own views regarding the judgment. But what I would like to know are your views. Does the judgment tries to achieve a balance between one party trying to start the arbitration and the other party trying to resist the arbitration. And secondly, if this is correct, then is this kind of a balance really necessary, or should all the disputes should immediately go to the arbitration?
Thank you, Dhirendra. Thank you for that brilliant introduction, first of all, where you said almost nothing about me. Much appreciated. But no, Dhirendra is a good friend of mine, so sort of permit that little sort of joke before we kick off onto more serious things. So Dhirendra, I think it's important in the context of the constitution of the tribunal and the appointment provisions under the Act to actually know what was happening before the previous amendments which have come about to the Act. The sort of ground reality which many in the room have faced is, of course, that there was an interminable delay before the court actually appointed the arbitrator. So the normal ingenuity of lawyers in India sort of prevailed, and several jurisdictional objections were always raised at the appointment stage before the courts. The courts in the early days of the Act entertained them at great length, passed lengthy judgments, so on and so forth. The contours of Section 11 were then narrowed down by a series of judgments by the Supreme Court. I think the judgment which perhaps did the best job of doing that under the old regime was a judgment which is known as Bogara Polyflab, where actually one of the best arbitration judges, Justice Ravindran, did a pretty good job in saying that you can raise a narrow set of disputes before the court at the appointment stage, which we'll look at, but the rest have to be considered by the arbitrator once the arbitrator stands appointed. We don't have to, of course, discuss the sort of competence principle. You know, this is a sort of expert audience and they'll all know about it. So the idea being that whatever jurisdictional objections you have, you will rightly raise before the arbitrator, and he will decide his own jurisdiction. Unfortunately, the Bogara judgment also was not uniformly followed by all the high courts. And as you know, that for domestic arbitration, the appointment procedure is that you go to the relevant high court or to the relevant originating court. So the Act came to be amended, and came to be amended, in my view, quite on a salutary basis, where they sort of further brought down the scope of discussion at the stage of the appointment of the arbitrator stage. Vidya Drolia, the last of the judgments which have now dealt with that. Incidentally, Vidya Drolia is nowadays an authority for almost every proposition under the Arbitration Act. It's a long, rambling judgment which has been written by the Supreme Court, where he discusses many, many things, not only the aspect of appointment. But on the aspect of appointment, the judge who writes the leading judgment sort of homes in on a principle which is now being called the deadwood principle. And what it in effect means is that the judge will examine the defense to ascertain whether actually the petition is really deadwood, in the sense that it's so obvious and so manifest on the face of the petition that the arbitration shouldn't take place. Pretty much everything else of any level of complexity goes to the arbitrator. So I think that he did strike the balance correctly. Reasons, I think, are not difficult to see. The whole point of arbitration is to be quick, expeditious, pragmatic. The starting point of arbitration was proving to be a considerable hurdle in the Indian context. So I think the amendment read with Vidya Drolia has more or less solved that problem. If you now are a part of a Section 11 application in the High Courts, it's dealt with fairly briskly. The change in culture which that amendment was to have brought about is on display now regularly in courts. And something that I spoke of yesterday in both the sessions that I was participating in, actually, it's part of a broader change that Indian courts have now exhibited when dealing with arbitration cases. I think they have all realized and learned from the mistakes of the past. I think that Indian courts are now painfully conscious of the fact that they've got a lot of bad press, and they're keen to redress that situation. So I think in conclusion, I would say that it strikes the balance properly. There was not much of a balance to strike, actually, truth be told, after the amendment, because if you read the amendment quite literally, it doesn't allow a lot of debate at the Section 11 stage, but it got it right. And it's always useful to have a pronouncement for the Supreme Court. My one reservation against several of the arbitration judgments, including Vijaya Drolia, is that I would much rather that they didn't use extraneous language which is not used in the statute. So the use of the word deadwood, which is not a term of art, has now resulted once again in those very ingenious lawyers who sort of spent many hours at the section level defense stage, now going into the question of what exactly we should mean by deadwood. But I'm not sure that they will have a very long rope. As I said, I think the patience of the arbitration court and courts in India has now worn thin on this aspect. And I think it's pretty obvious. What is deadwood means something that's just not going to fly. So in answer to your question, I think that Vidya Drolia has struck the balance, and I think that the courts who are dealing with these type of applications have properly understood it.
Thanks for your views. Now, Stephen, following from what Zal has said, and I'm talking purely from the point of ad hoc arbitrations and not institutional arbitrations. And you have worked as an arbitrator in so many jurisdictions, and of course you have so much experience and knowledge about what happens across the jurisdictions, not only in the East but also in the West. What has been your experience as compared to the Indian scenario about which you're well aware of? That in respect of the ad hoc arbitrations, do parties really spend so much of time? Is there so much of case law floating around? 2 judges, 3 judges, 5 judges, 7 judges bench deciding only a question of appointment. So would you like to share, at least to our benefit, what is the status around the jurisdictions?
Thank you for that question, Dhirendra. Well, let me approach this with an anecdote, which is when I first started sitting in India, and I had to dig into it. It actually concerned a case of stamp duty. Before NN Global went its way up the various benches in the Supreme Court, and I had to dig into these judgments. I think actually it was the Garare Wall judgment that Justice Rohinton had written, and it was an eye-opener for me to see how Section 11 is dealt with, and as Zal had mentioned, the various changes in Section 11 legislatively as well to limit the scope. It was an eye-opener to me because in all the years that I practiced in arbitration, I had not appreciated that the appointment of an arbitrator gives rise to so much litigation. It doesn't happen. With that as an introduction, let me explain why that is the case then. First, by reference to Singapore. So there isn't that much ad hoc arbitration in Singapore that requires a default appointment by the statutory appointing body. There is ad hoc arbitration in Singapore, but most of it happens in the construction sector, and it happens where there is an appointing body as part of the scheme that actually makes the appointment. You do get appointments of ad hoc arbitrators, but how that's dealt with in Singapore now is that through a legislative amendment, the court has actually made the president of the SIEC court the appointing authority in Singapore. So it then becomes, appointment of an ad hoc arbitrator becomes more of an administrative function, because it's not a judicial function. It goes before the president of the SIEC court. I have been appointed in ad hoc arbitrations, and I get a letter from the SIEC saying you have been appointed by the president. And there is no judicial process around it. There is certainly no judgments around it because it is made by the president. What does the president do when he considers it? He does, as under the SIEC rules, would consider whether prima facie there is a arbitration agreement at a very prima facie level. And if there is, he will make the appointment any jurisdictional issues, and there are jurisdictional issues, when the appointment is made, is then left to the tribunal to be dealt with. That is one approach. The other approach in England, and it's not very different from how it's dealt with in India. In fact, the leading case on that is a case of silver dry bulk and Homer, but which is cited in Videodrolia. It's one of the cases cited. And the English court in that case, took the approach that it is the standard to be met as a good arguable case. And the judge made it a point to say that a good arguable case is a low standard. He wasn't setting a high standard. It's something that can be argued, but it doesn't have to be shown that it's more likely than not that it's going to succeed. So they set a pretty low bar. There isn't, though, much case law about this issue. I had to look into this because I wasn't aware of any off the top of my head. It doesn't come up very often. In fact, the case that I cited, Silver Dry Bulk and Homer Halbert, wasn't actually a case about appointment of an arbitrator, an ad hoc arbitration. It was a case where the tribunal had been appointed, and in a case where the respondent wasn't participating. And the claimant then went to the court to ask the court to confirm that the tribunal had been appointed validly. And the court actually said, well, actually, that's not what Section 18 of the English Arbitration Act is for, and actually declined. But there was one case that was referred to in that. It's the case of Noble Denton Middle East and Noble Denton International, where it was a case under Section 18, which was an appointment. So there are not many cases that come up in England and in Singapore dealing with the question of appointment of ad hoc arbitrators. Before I move on, and I think you want to hear from Clara, let me just make some comments about the bigger issue that you raised, which is what is the balance between the court and the tribunal in terms of dealing with this question of jurisdiction. Is actually a complicated issue because of the way the New York Convention is structured, which ultimately is the foundation. I'm talking here primarily about international commercial arbitration, leaving domestic arbitration out of it. The way the New York Convention is structured, which is the foundation for the modern system of international arbitration, is that ultimately the courts reserve the right to deal with the question of jurisdiction of the tribunal. Basically, is there an arbitration agreement? Is there a valid arbitration agreement? So the question then arises, in that context, should there be, as in some jurisdictions, which is in India, Singapore, and other jurisdictions which where the court, when dealing with the question of validity of the arbitration agreement, either at appointment of an arbitrator or also when granting a stay of litigation proceedings in favor of arbitration, should there be deference to the tribunal? Not Singapore and India and many other jurisdictions take that approach. When I've looked into this further, and some of you may know Gary Bourne, who is one of the leading commentators in arbitration, one of the leading arbitration practitioners. And Gary took a different view to say that there shouldn't be either an approach which is there should be deference to the tribunal at that stage, or alternatively that the court should go into a full review, but it should depend on the facts of the case. And the reason he took that position is something that you raised, which is, what is the equity and justice between a party that says there's an arbitration agreement and wants to enforce that, and a party that says there isn't an arbitration agreement and doesn't want to be dragged into an arbitration. And he says in that sense, the equities are fairly balanced. Both parties have an interest. The party that wants to enforce the arbitration agreement has an interest in seeing it enforced, but the party that says there isn't an arbitration agreement is entitled not to be dragged through an arbitration and have the court decide it, because ultimately the court has the function under the New York Convention to decide jurisdiction. So it's a difficult question. Has India got it right? India is along with many other jurisdictions that actually gives deference to the tribunal by saying that it would take more of a prima facie view on things. I was up at 5 this morning with jet lag and had the opportunity then to go through Videodrolia. It's a long judgment, as it says now. And reading it through, there's nothing that I can say that's wrong about the judgment and the analysis. I can see that there's good reasons, and going through Videodrolia, it cites lots of authority in all different jurisdictions, England, the US, and commentators as well. You can't see anything that's wrong about that. But people still complain about the appointment of, ad hoc appointment of arbitrators in India. It's not the law that is the issue, but other factors that you have. I heard this afternoon someone complaining about how long it takes in the Mumbai court for a Section 11 to be heard. I hear things are better in Delhi. Many people have said that. So it's not a question of the law. It's a question of more, in particular jurisdictions, how the courts are functioning. There are other issues at play. It's not the law that you're grappling with.
No, but Stephen, given the peculiarities of a particular jurisdiction, like you said, Section 11s, it may take years for a Section 11 to get decided. And in knowing that peculiarity of your own jurisdiction, shouldn't be better to mold the relief or live up to the expectations? And why can't a tribunal decide the same questions which a court can decide? See, that's what bothers people. If I have agreed to an arbitration agreement, why can't the tribunal decide that issue? So on that point, I'll first take Clara's views on that. So Clara, what do you think this balancing act and the fact that when parties have agreed for an arbitration agreement, why can't the arbitrator decide all those questions which the court sits beforehand and cuts the deadwood, as what Zal referred to?
Thanks very much, Sharon. And I have considered this question from sort of the same angle as Stephen when he first started his introduction. He mentioned looking around for case law on arbitrator appointment disputes in the UK and Singapore. And the short answer is that there actually just isn't. And perhaps that in and of itself illustrates a little bit of the difference between the jurisprudence that has grown up here and that in many other international contexts. And I would hazard to say that it is not indeed the case everywhere that arbitrator appointments are not an issue, but in the jurisdictions that I've practiced in, so Singapore and the UK, definitely, it is just not one of those issues that tends to crop up, or rather that parties have found it worthwhile to make crop up in an arbitration. And that probably has a few reasons, one of which is the very light touch approach that the relevant national laws have in relation to appointment of arbitrators. So in Singapore, the Singapore law, basically, the Arbitration Act says essentially nothing really about the qualifications of arbitrators to be appointed. It's the model law, and it just says that parties are free to determine the qualifications, the relevant qualifications. And that in and of itself gives perhaps less grounds and less bases for parties to then raise that as an issue. There are other gateway issues to do with constitution that can be raised, obviously jurisdictional issues, validity of arbitration agreement, but the appointment stage just doesn't, quite, it's not the issue that is often disputed. And then the other aspect would be, as I think we've all mentioned, the fact that there is the fallback of institutional arbitration. So in most cases in Singapore and in the UK, we've seen it's institutional arbitration. And if in the event that parties are not playing ball and the appointment mechanism falls away, then there is a default, a fallback, which is that the institution will go ahead and do it. There is, and so the jurisprudence that has grown up has really been in relation to, and I think that is where perhaps the question lies. The dispute has then been on the parties' consent. So what have the parties agreed to in relation to the appointment mechanism and the validity of the arbitration agreement? So a lot of the jurisprudence in Singapore is about the validity of the arbitration agreement and whether or not it's a valid clause, whether it is a pathological clause. And I actually think that is where the law the jurisprudence should slant, because arbitration is a creature of contract. And if we want to understand what, how this industry is going to grow up and what clients want, how clients want to decide their disputes, then the time and energy we should be spending as an arbitration community is on understanding contract law and not on arguing about appointment mechanisms. So I do think that, not to sell out Singapore or anything, but I do think that when the law is turning to making us as lawyers read our textbooks and understand what is ostensible authority and is there an implied consent and is this the way you draft a contract such that the clause is not pathological, that is where that's where we want to grow our jurisprudence. So yeah, that's my answer.
Sure,
Can I answer the question you put, which is why can't tribunals decide it? The answer is tribunals can and should decide it. The thing is, the court and tribunals both have a concurrent duty to decide the question of jurisdiction. And in a case that I'm dealing with, I had to deal with this issue because there was a question of a joinder of non-signatories, which I know you want to come to later. In that case, proceedings were brought in the Malaysian court, which was not a seat, brought in the Malaysian court to deal with the question as to whether indeed these parties were signatories or not. I was an arbitrator sitting in Singapore. I was asked to stay the arbitration pending the decision in the Malaysian court. So I had to look at the issue and consider the issue. And I came to the conclusion with authority that tribunals and the courts have concurrent duty, right to determine jurisdiction. So I said, I'm not staying the arbitration because whatever the Malaysian court decides is not definitive on the issue. And even if whatever the Sikh court decides, and there was authority on this as well, is not definitive of the issue. In the context of an international arbitration, I have to say, in the context of an international arbitration. Because at the end of the day, the courts have the duty to decide it, but so does the tribunal. And the tribunal and the court both should decide the issue. I just wanted to squarely answer the question that you put.
Thanks, Steve. Just coming back to you, Zal, on this. We are, in India, all very hopeful that one day institutional arbitration will really pick up and everybody will go for institutional arbitration so we don't have all these kind of issues. And this is what the amendment to Section 11 looks for when they say that now the institutions designated by the High Court or the Supreme Court would make the necessary appointment. So this whole debate about validity, existence, arbitrable, not arbitrable, will go at the stage of appointment. But at the same time, we have two provisions, Section 8 and Section 45, meaning where if a party starts a civil action, then the court may or may not refer the parties to the arbitration. So how these two different worlds, one world of Section 11, where there is no question of getting into existence, validity kind of question, and the other world where the court is seized of a civil action and the other party moves an application saying, please refer this matter to arbitration, we have an arbitration clause here. So do you think there's going to be a conflict, or people would cite like, look, now the law has changed, so you should also change, and don't go back to the philosophies laid down by the courts earlier?
Thanks, Dhirendra. Just before I sort of try to answer that question, I just wanted to comment on something that Stephen said actually, which I think would be a salutary approach for our courts to adopt. I did say in answer to the initial question that the one criticism that I did have of Vidya Trolia was that it didn't formulate the test correctly. During Stephen's answer, he pointed out that the English courts, when in different circumstances they were asked to answer the question, they first formulated a test, the good arguable case test, and then they answered that test. I think that's an important point for our courts to bear in mind, and especially our Supreme Court. They must remember that actually they are laying down the law for the other courts and of course for the litigants. And if I were writing in the Supreme Court, I think one of the things that I would go at great pains to do was to first formulate the test correctly and then answer it. So nothing wrong with Vidya Trolia, we all agree. Could have been shorter perhaps. And in all those 100-odd pages that they actually discuss the law from various jurisdictions, to my mind, they missed doing that most important task of actually setting down the correct test in legal terms and not in sort of non-legalistic language. So that is just the comment I want to make on the point that we made, and that was sort of teased out by Stephen's answer as well. The other point, which also ties into my answer to this question, is what both Clara and Stephen spoke about, the fact that actually because of the entrenched nature of institutional arbitration in, let's say, more developed arbitration jurisdictions or jurisdictions which have been doing commercial arbitration longer than us, is that this whole question with regard to appointment of arbitrators loses its judicial character and it actually becomes an administrative task. It is not entirely atypical for our courts to say things and forget about them. And I fear that this has also happened in the context of administration, because many of us do know that in the fairly early days of the dispute with regard to Section 11, I think it was a judgment called Swiss Timings, if I'm not wrong. In Swiss Timings, the Supreme Court very clearly said that Section 11 judgments don't have precedential value because they should not be regarded as the exercise of judicial function, but administrative function. It seems to me that most courts have lost track of that principle since then and written long and lengthy judgments, and of course, the Supreme Court itself then in Vidya Trolia, which is widely regarded as a precedent. But I think it is important to bring about that distinction, to say that appointment should now translate into an administrative function and not a judicial function. So, of course, if we have the appointing institutions recognized and taking effect, I think that we'll have a much quicker and speedier way to actually appoint arbitrators. We won't have sort of the scope for lawyers, long, lengthy legal arguments, and we won't have scope for judicial ramblings on the part of the court as well. So I do think in theory that, yes, that would be a big improvement in the area of appointments. The only reservation that I have there is that when I do practice in many tribunals also, which are manned by a judicial and a technical member. And I do sometimes find that the technical member always lacks a holistic approach to the problem. I often find that they are solution-oriented, but not viewing the problem in its entirety. So I fail to see how that could be a problem in the context of appointment, because of course appointment is a sort of binary task, right? Either you appoint or you don't appoint, and you appoint X or you appoint Y. So in my view, I think it should be a considerable improvement. It should speed things along. We will, of course, lose what Stephen rightly said, the really passing of the baton between the courts and the tribunal, in the sense that if you make it an administrative function, it's pretty much then going to be for the tribunal to decide all aspects of jurisdiction once the appointment takes place. But to your point, Dhirendra, I think that might be a good way to approach it in India, where the courts are very overburdened. Getting a hearing takes a long time. Even disposing of a Section 11 takes a long time. So maybe an indigenous solution that will work well in India is to have an administrative appointment and to send things straight to the arbitrator.
Thanks, sir. Now, this was a little bit discussion on the constitution of the tribunal, the first hurdle which the parties in India or any party dealing with the Indian seat of arbitration often experiences. But moving forward, there is one critical issue, though, which doesn't arise often, but whenever it arises, it gives a lot of pains to both the parties as well as the tribunal, and that is the issue of joinder of non-signatories. Now, I may not be wrong in saying that law is more or less as it has developed, particularly India. It goes on to say that in certain circumstances, a non-signatory can be included as a party to the arbitration, and I believe so is the attitude of the courts even in other jurisdictions, subject to correction. But my first question on this point is something very basic, and this is for you to Stephen, for you to answer. Do you think this whole concept of joining a non-signatory is really antithetical to the concept of party autonomy? Now, please consider it from the point of view of the party which is being joined, not from the perspective of the claimant who wants some relief out of that non-signatory.
The short answer to your question is no. I don't think it is antithetical to the question of party autonomy. Joinder of a non-signatory can only take place within certain, I would say, rather limited constraints. And it's an issue that I'm dealing with right now, because I have a case where there are non-signatories and the question is being whether they can be joined. As Clara mentioned, an arbitration agreement is a contract, just like any other contract. And we all can accept that under contract law, a party can accede to a contract. So a contract can be signed between party A and party B, but subsequently party C can either become an additional party to that contract or can replace party B. And that's one of the situations in which a joinder may happen. Again, applying contractual principles that, in accordance with contractual principles of whichever is the governing law of that arbitration agreement, that party has become a party to the arbitration agreement. So joinder can only take place in the limited circumstances where a party which is a non-signatory, which hadn't signed the arbitration agreement, has become a party to that arbitration agreement. There are other contractual principles that are relied on. You have a famous case in India, Clara controls, which deals with the question of whether the group of companies entity can apply. It doesn't apply everywhere. It is part of the Indian law. So it is in that limited context. And the reason why I say it is not antithetical to party autonomy is because what ultimately would govern the question of joinder was a contract created, in this case, the arbitration agreement, was that created between the party that wants to bring the non-signatory in and the non-signatory. That's what defines the issue ultimately at the end of the day.
Okay, Stephen, I'll come back to you on this point that you said. But before I do that, Clara, what are your views, and do you have any experiences where you saw or you experienced the struggle of a non-signatory and the signatories before a tribunal or before court?
Yeah, thank you. So Stephen mentioned something which, and of course, it's trite that an arbitration agreement is just a contract. But I think when I was thinking about this issue, it did strike me that the reason why I think we experience so much sort of pain and contention, well, in a way, it's not really, pain, because there are clear contractual principles to guide this analysis. But the reason why we feel conflicted maybe is because an arbitration agreement, while it is just a private bilateral contract between party A and party B, there is that sense that it also sits somewhere in the wider framework of the administration of justice, and that there should therefore be, in some quarters people say, some element of, borrowing from court procedure to make sure that this function is working as a efficient and one-stop shop administration of justice. So in the court context, there would be no issues with joining any party that was regarded as required to be required for the efficient disposal of the case, for example, under civil procedure rules. But in the arbitration context, and there is the temptation of many arbitration practitioners and tribunals and even legislators or drafters of institutional rules to feel that perhaps some of that element should be borrowed into arbitration, so that every party that is related to the case in some way should be able to be brought in. And so there is a little bit of that tension, I feel, between the respect for party autonomy as central to arbitration, but yet the fact that arbitration is also within a wider framework of the administration of justice. But then coming back to whether it is antithetical, the joinder issue is antithetical to party autonomy, I think that as long as the analysis is always grounded in contractual, consensual consent, looking at what the parties intended, then it would not be. But there are scenarios where, and I'll raise two, where there are that it may be that the law is straying into areas where it's not actually looking at party consent. So in terms of party consent, all your usual sort of grounds of adding a non-signatory as a party would be agency or estoppel or implied consent. And these are not, these do not do violence to the principle of party autonomy, because you're basically interpreting on the facts. The issue is just evidential, whether or not on the facts the third party, as it were, had actually expressed an intention to be part of the arbitration agreement. I think the most contentious issues would be, as Stephen mentioned, the group of companies doctrine, and perhaps the second would be the concept of third-party funders, which is now becoming more a very key issue. And the third would be, and perhaps related, the question of whether institutional rules should be drafted so as to conceive of or to allow the joinder of the non-consensual joinder of third parties. So in terms of the joinder of parties who are in a group of companies, I think there's a recent Delhi High Court case actually where Justice Yashwant Verma, I think is a great judge, decided that the group of companies doctrine was in that particular case should not be applied, in that it would do violence to the principle of the consensual basis that's so integral to an arbitration agreement. And I think interestingly that the parties who had sought the joinder actually referred to an earlier case, which I think is GMR, where it was decided that the group of companies doctrine would apply. And Justice Verma said that, that was a different case because that was a case that was conducted under the SIAC rules. And the SIAC rules do provide for joinder. However, the SIAC rules don't provide for joinder of non-consenting parties. There is a consultation going on right now where they are considering, I think, adding a third limb to the test to say that you can join parties where it is necessary for the efficient disposal of the case, which i.e. means broad enough to include a non-consenting party. But at the time GMR was decided, and in fact the present rules do not allow for joinder of a non-consenting party. So I'm not too sure where that lies, but basically the point is that it can be that that principle in particular strays into the area where it would be joining a party who, in spite of there is no contractual intent to be part of the arbitration, they are being drawn in. And then the second point would be what I've touched on, which is then should institutions be thinking that they should therefore include a limb in their test for joinder, which then could open the door, as in this recent case, to allow courts to say, well then, joinder should be allowed.
Yeah, thanks, Clara. See, what you've raised is an interesting point. See, apart from the question of party autonomy, and as was noticed in the judgment that you referred to, the question also arises as to who is going to decide that, whether a stranger can be included in the arbitration. Maybe for the courts have inherent powers, courts can pass such orders. But does the tribunal, which is a creation of merely an agreement, does it have power to include a third party in the ongoing arbitration between two parties? And in that judgment, the court used the expression that the arbitrators cannot create jurisdiction. And this, Stephen, connects to your point that in certain cases, it is possible to ultimately decide that the third party or the non-signatory had agreed for the creation of a contract where it would be included ultimately in the arbitration. But the point which is being argued these days, and quite a lot, is from where does before we come to the institutional part, that's a different thing, but how does essentially and fundamentally an arbitral tribunal gets the power to include a third person in the ongoing arbitration? So Zal, my question to you is do you see there is a, on the one hand, we broadly accept the principle that yes, in certain circumstances, parties can be included, and if there is a matter before court, be it for the appointment or be it for Section 845, courts can pass such an orders and say, okay, no, this party can also be included. And whereas the tribunals do not expressly have the power, at least, right? So how do you think this differentiation, is it really called for, or our tribunals are really helpless? And I mean, there is no way tribunals can tell to the parties, no, you go to the court, we can't do anything, given what the Delhi High Court judgment which Clara referred to.
Thank you, Dhirendra. Well, Dhirendra, I have to confess that I have always struggled with third-party joinder in arbitrations, and I think I do share some of the sort of theoretical and philosophical reservations, philosophical in the sense the philosophy of arbitration and party autonomy against joining third parties. It does seem at a theoretical level to be something which is, at least it does run contrary to the concept that both parties will agree that they will decide their disputes in a particular manner. But I have experienced this, of course, many times as counsel in arbitration. There is a crying practical need to actually join third parties in arbitrations if the whole process is not going to be frustrated.
Certainly, it has happened.
So I think that actually the whole joinder of non-signatory third parties is a doctrine that is based on pragmatism and the need to actually completely and fully decide the dispute. We're going to have many, many commercial arbitrations frustrated if we don't actually evolve an acceptable third-party doctrine. Those cases which Clara spoke about, Stephen spoke about, and which are well known, they sort of come quite close to where the philosophical objection meets the pragmatic need, in the sense that the sort of underlying theory behind all those cases is that the third party is really not so different. And in one sense, the third party is the counterparty to the arbitration. So I think that the practitioners and the courts have all recognized this pragmatic need. And it's not perfect, but I think that we are coming close to an acceptable doctrine, which is restrictive in nature and has a considerable threshold to be crossed to actually join non-signatory third parties. As I said, I think that it is actually a doctrine which is informed by sort of the practical reality of arbitration and commerce today. Chloro control, I think, has always been a difficult judgment to understand. Fortunately, it's not only me who's sort of struggled with chloro control at various times. I'm sure many in the room know that chloro has now been doubted by our former Chief Justice. It's now been referred to a larger bench for reconsideration. I'm not sure about the status of the matter.
I think the arguments are concluded.
Oh, I see, the arguments are concluded. But chloro itself, the principle of chloro as a stepping stone led to several other judgments which slightly expanded the scope of chloro. And once again, I think we'll have to await the judgment of the full bench on where chloro finally lands. Do they uphold it, or do they change it a little, or what they do with it? But it was a very confusing judgment to say that you've got to locate the mother agreement and then you've got to sort of, do all of that.
It was a fact specific, but they included a lot of principles, whatever principles were floating around, all of them were captured.
At a practical level, it's always been sort of read by both sides in their favor. So a little of what I said before, I don't think the test was properly tightly formulated. It's a difficult task, but hopefully they'll do a better job when it comes out of the full bench doctrine. And of course, as Clara spoke about, we have sort of a slightly different doctrine also, the group of companies doctrine, which has also been used to join third-party signatories. So I think that, yes, it's necessary, but we are going to have to wait and see what the determinative test that we're going to use to join third parties is. I think it's also very confusing under the Indian domestic regime that in Section 9 proceedings you can always join third parties, but in Section 17 proceedings, just for our foreign visitors, Section 9 being the interim measure that you make to the court, as opposed to the interim measure application which you make to the arbitrators. It's a very, very confusing situation where in the Section 9 proceedings you can join third parties. In Section 17 you can't. I tried very hard to persuade an arbitrator a few months ago that with the statutory parity that was drawn between Section 9 and Section 17 by a specific amendment, that the two stood on the same footing and that he could now reach out and join a third party in Section 17 as well. I failed, and I think the challenge to that failed as well. So the position at least, and there's a differing position across several courts, but the position at least today remains a somewhat confusing picture. You can definitely join a third party who doesn't have to satisfy any of these requirements for the purpose of getting effective relief under Section 9. You can't do it under Section 17. And if you're going to do it in the arbitration, then you have to apply this somewhat sort of difficult to understand chloro control test or the group of companies doctrine. So state of the law, I think, could be clearer, could be better, and hopefully we'll get there. But in summary, I think it's a discussion which needs to be had, and I think it's a solution which needs to be found.
Yes, I agree there with you, Zal, and possibly maybe some kind of a legislative enactment would be required, because the situation as it stands today, and this question is to you, Steve, if you and I entered into an arbitration agreement, and we say Zal will be the sole arbitrator, and he will do ABC things, and we hereby confer the power or authority upon Zal to include any third party in the arbitration if the need arises. So is that agreement an ad hoc agreement good enough, or does it serve the basis, the foundation of the authority for Zal as an arbitrator to call the third party and say, hey, listen, I've got this authority from this agreement, you have to join. And I think prima facie, and I'll give you an opportunity later, but prima facie I think you are a party. So does that confer?
The agreement that you described, this ad hoc agreement, would only bind you and me as the party. So what we're doing effectively is saying to Zal, we agree that we will arbitrate not between us two, but any other third party that is prima facie a party to the arbitration agreement. That, however, does not include the third party. So it doesn't give Zal the power to go and say, you are prima facie, party C, a party to the arbitration agreement, and I can join you. I don't think it works that way. The institutional, it's important to bear in mind as well that the institutional rules dealing with joinder are dealing with joinder as a procedural aspect, not as a substantive aspect. What I mean by this, if you look at the institutional rules on joinder, all of them reserve the position that joinder, whether by the institution or by the tribunal under those rules, is without prejudice to the tribunal's decision on jurisdiction. So that issue is reserved. That just because a party is joined, it is joined only for, and as a procedural matter, that the party then participates in the arbitration and has the opportunity in the arbitration to make its case, including as to whether it was properly joined or not. So in the ad hoc situation that you described, it would ultimately require, I would say, still the agreement of the third party. There's nothing in that ad hoc agreement that binds the third party. It only binds the parties A and B.
Yeah, no, because I'm asking it because in some of the institutional rules, like ICC, I'm sure, it is purely consensual. In the sense, I don't remember the rule, but it says expressly that it has to be with the consent of either the parties and the party who's being joined in. Otherwise, arbitrator has no power. But in contrast to that, the institutional rules of SIEC and Hong Kong Arbitration Center take a two-step procedure. First, a third party can be joined if either the parties agree, or if the tribunal or the registrar or secretary general, whatever it's called, takes a prima facie view that yes, third party, this arbitration agreement covers a third party, and then as a next step, like you said, the final decision goes to the arbitrator. But don't you think this is an indirect way of expanding the jurisdiction of the arbitrators? Merely because it's an institutional rule. What I can't do under an ad hoc agreement, can I do it by way of the institutional rules? Because see, ultimately it will be the tribunal who will be deciding whether it has jurisdiction or not. So this difference in approach of the different institutions, don't you think that would leave parties a bit confused as to where do we stand? And especially when there is a multi-party transaction, where there are different kinds of contracts with different kind of entities, maybe connected or affiliate companies. So I again come back to the fundamental question, are we really overstepping when we feel that yes, arbitrators should, in circumstances, and without any legislative backing, should be allowed to include third parties and pass orders against them?
The institutional rules, as I said, it only gives the power to join as a procedural issue. It doesn't decide the substantive question as to whether or not that party is properly a party to the arbitration agreement. The institutional rule takes the place of the ad hoc agreement that you described. In effect, by agreeing to these rules, you agree that a third party may be joined if that third party is prima facie bound by the arbitration agreement. Again, it doesn't bind the third party. It doesn't give the tribunal a power to say, third party, you must come in. The tribunal can say, and usually it's going to be the situation where between party A and B, it may be that claimant has brought a claim against party B. Party A has brought a claim against party B in arbitration. And party B says, no, we have to have party C involved as well because party C is properly a part of the arbitration agreement. So the institutional rule then deals with the situation at least between A and B to say that A cannot object to say, no, you can't bring in party C. So long as party C is, the arbitrator can make the determination or the tribunal, the institution can make the determination that party C is prima facie bound, then at least between A and B, you can't complain. Whether party C then decides to participate or not is a question up to party C. They can decide not to participate if they want to. So in that sense, it's not creating anything which is not which is that different from the ad hoc agreement. The ad hoc agreement gets to the same point, except that you must have party A and B to expressly agree to the arbitrator to say that we consent to any other third party coming in. The slight difference being then that in the institutional case, even though there wasn't that express consent, by agreeing to the rules, you actually consented to it. So party A cannot say, no, I don't agree to have party C involved because of whatever objection, because you have agreed to the rules, and then leaves the tribunal to make the determination, or the institution to make the determination whether that party is actually a party to the arbitration. It's prima facie a party to the arbitration agreement or not. With the caveat, as I said all along, that it reserves the question as to whether that party is actually properly a party. So whatever joinder happens under these rules remains subject to the point that whoever is joined, or whichever party, even between party A and B, you join C, party A can still say, yes, he's now joined, but we still say he's not a party to the arbitration agreement, and that issue still has to be decided by the tribunal.
On your question as to whether the tribunal or the court should decide, there is that tension there because it's a little bit chicken and egg. Who is going to decide this issue over these three parties when one of them arguably should not even be part of this process at all? But I think that is the case with a lot of, and it comes down to a jurisdictional challenge where the remedy for the third party who is then, arguably wrongly joined and should never have been part of the party at all, should then take up his relief before then the courts, because the tribunal at the first instance will have the decision over its jurisdiction over that third party, right, competence. But then there is the recourse to look to the courts and say that there is no jurisdiction over me, and then there is setting aside at the setting aside stage or the enforcement stage. So actually this was precisely the issue in the Singapore case of Astro and Lippo, which has turned out to be sort of a leading case on the two bites, sort of the choice of remedies principle, where it said that someone who wants to challenge jurisdiction can have two turns to do it. They can do it at the initial stage when the tribunal issues its jurisdictional award. And that was a jointer case. It was the Astro group against the Lippo, the Indonesian Lippo group of companies over some telecoms tower satellite services. And the Lippo group parties were joined to the arbitration, and an award rendered against them even though they were not party or signatory to the agreement. Then they tried to get it, they tried to challenge jurisdiction, or rather they did not challenge jurisdiction, and they just didn't participate. The award was rendered against them, and then they sought to set it aside. And the question was, should they have raised the jurisdictional challenge earlier? By not having raised it, had they waived their right to then challenge the award? And the Singapore Court of Appeals said, no, you get two turns to do it. One is an active remedy, where if a award is issued against on jurisdiction against, you can challenge it at that stage. Or you can just sit on your hands. You don't have to incur legal costs. Just sit there and wait for them to come and try and enforce it against you, which they then did all over the world. And then there ensued all these setting aside and resisting enforcement, which the Singapore court at least found that they were entitled to do. And then the Hong Kong court also, I think, did the same. So that it's an incomplete solution in that, you know, it's not nice, I suppose, to be joined to a agreement or bound to do something, or purportedly bound to be involved in a proceeding that you never agreed to. But like Stephen said, it's sort of a practical and administrative solution so that the dispute resolution process can continue, and then you ultimately at the end of it, or in the midst of it, have recourse to get yourself out of it through the mechanism of the arbitral, the rules that are. And I think then it comes a little bit down to a combination of the rules and the seat of arbitration. What does the governing law of that governs the arbitration say the recourse for parties who dispute jurisdiction, where can they raise it? So that's, you know, as between the tribunal and the courts, I think it would be a little bit of both. The tribunal at the jurisdiction stage, and then the courts when it comes to a jurisdictional challenge or setting aside jurisdictional challenge. Setting aside.
Thanks. Zal, just a quick question for you. Sorry, you wanted to say something?
Shall I?
Okay, sorry.
Okay. No, I just want to point out that what Clara said is very much the position in India today. A party who's joined as a third party obviously has choices to make. Does it enter the arbitration? Does it protest? Does it wait and await the outcome of the arbitration? Because of course no award may be passed against you. And in the event that an award is passed, do they raise a challenge to the arbitration award on the third party aspect? So that's pretty much our position as well. I suspect it's pretty much the position in most arbitration jurisdictions as well, because you are dragging the third party into the arbitration, and the third party is not the signatory. But what I did want to actually comment upon, Dhirendra, was your sort of illustration which you gave us about whether there could be a solution along the lines that parties A and B go for an arbitration with a provision that the arbitrator will be free to join an appropriate party. I've said this in the beginning, and this is my experience with arbitration in India. I think there is a crying need for clarity on many aspects of arbitration, and I think that could not be more true for third-party joinder. So I would argue against such a solution. I would argue for a solution where the test should be carefully, legalistically formulated by the Supreme Court, and we now have an opportunity for that to be done. So I think that's the best possible outcome for the third-party solution.
Thanks. If I may just come back to that quick question I was asking you, related to this, but not really on the point. See, now we have the IIAC in place, and this center, India International Arbitration Center, has been constituted under the Act, and it has been given power to frame regulations. Now, regulations have come into force it says conduct of arbitration regulations. I think India is the only country which has this kind of a setup. And coming to the point of joinder, it has a similar provision as what is there in the SIAC. That's two-step procedure. First, prima facie review, and then the question to be decided by the tribunal. But my question to you is that being an act done by the arbitrator under a regulation, do you think it will give opportunity to the parties to go before the writ courts and challenge all these kind of decisions which doesn't suit them, merely because everything is being done under the... I mean, just a thought came to my mind when I was going through these regulations. So, because otherwise, if that's the stand, then it'll open up a Pandora's box, it'll do more harm than what is this. Do you think that's a possibility which could happen?
Once again, just to reiterate what both Clara and Stephen said, that I take it that the IAAC's power is going to be to procedurally call in the third party for the hearing before the arbitrator, before the joinder actually takes place, in the sense that it's an administrative body. The joinder of third parties is a complicated legal question. So I take it that the regulation will say that in certain circumstances we'll call in the third party, and the third party can then be heard on whether he should be joined or not. That's right, isn't it? Yeah. But your point with regard to...
it's just an apprehension that,
I'm just about to address that actually. So gratifyingly, I have noticed over the last several years, something once again I said earlier, that the civil courts and the writ courts are now very, very cautious about interfering in arbitration matters. It's almost impossible to get a writ issued in an arbitration matter, for obvious reasons. I mean, we don't often have state instrumentalities on the other side. And just for our foreign visitors, the writ petition is effectively an application for judicial review, sort of analogous to the application for judicial review. So one is the non-interventionist aspect that the courts have now taken, and rightly so. The second is, of course, our Act has a specific provision which argues against court intervention, which is Section 5. So I, for one, have many apprehensions about the sort of future of arbitration, but I don't think an overbearing writ court is one of them. So I think that the writ courts have matured. I think they've understood arbitration a little better. They've understood that arbitration is best served if the writ court doesn't intermeddle in arbitration. So I don't think we'll have that.
Thank you, sir. Moving, I think we had quite a good discussion on at least these 2 points. But quickly moving, one aspect which is again very unique to the Indian arbitration is the time limit for passing the award. So this will be very quick. What is your experience? That has it proved itself out? It's been good, it's been bad. Yes, it's for you.
My experience has been it's very difficult to pass the award in 2 years. I've done, in my more junior days, I used to do a lot more of domestic arbitration, and that included a period where this amendment had come about. I found the whole arbitral process and the sort of culture of arbitration in India made it a great challenge to complete it within 2 years. And the sort of main culprit in all of that, of course, was the evidentiary stage of the arbitration, which my experience in Indian arbitration is that it is given too much time, counsel are given too much latitude, and there is another urgent need in this area where the arbitrator should first work out what is the need for oral evidence. My own experience in closing arguments is that a lot of that time is wasted. Counsel very, very infrequently actually refer to the oral arguments in India. Commercial matters can be decided in large part based on documentary evidence as well. So given these factors, the culture of conducting the arbitration, the culture of not interfering with counsel when they're doing a lengthy cross-examination, I think that limit has been quite challenging. There are frequent applications in the Supreme Court, in the High Court for extension of time. But I don't think it should be amended. I think our culture should change. And we should seriously work on how we can finish the arbitration within that period of time. I don't know, I'd be interested to hear what Stephen and Clara think on a 2-year limit to finish heavy commercial arbitration. Is that workable, or can you do it?
Well, very quickly, I think it's difficult to put every case into the same straitjacket. It really depends on case. There are cases you can finish within months, and there are cases which you will struggle to finish it within 2 years, including passing the award within 2 years. So it's difficult to put every case within that straitjacket and say this is the standard that all cases have to meet.
Yeah, I think from experience and from the point of view of counsel, it is always a positive thing when the proceedings are conducted, in a very I wouldn't say under the expectation that there's at least a timeline, a point of reference for parties and the tribunal to work towards, even if that timeline is soft. And I think the Indian position right now is that there is a soft timeline for international commercial arbitrations. There was a time when the timeline was hard, and we had an arbitration that was literally conducted within that timeline. It was started in mid 2017, and the whole thing was over by 2019. A multi-billion-dollar PSC arbitration that was completed within that time because of A, the hard timeline under the Indian law, and B, a robust tribunal that proactively managed the case. So that was very, very positive for at least the parties who wanted to get it done. I think now that it's been, I wouldn't say watered down, but changed to become a soft timeline, that's still valuable in that there are many arbitral rules out there, not that many governing laws, but arbitration rules that do impose a soft timeline. The LCIA, for example, has a 3-month timeline for the award to be rendered. The SIC is also considering having a soft timeline. But the position is that at least it gives parties a point of reference, and it gives the institution, if there is an institution, some basis to crack the whip and to say, the timeline is ticking. Even if then the timeline is extended, somebody needs to apply for the extension. It's not just an open book. As to whether, 2 years or 6 months or 18 months is the correct thing, I'll defer to the illustrious tribunal members here. But all there is to say is I think 3 months and 6 months is very short. And the SIC is right now contemplating a 3-month streamlined procedure. I barely even know an arbitration notice has been served against me in 3 months, but a 3-month procedure for sort of low-value claims or urgent claims. And there is the expedited procedure. So in the absence, I suppose, of a governing law which imposes a timeline, then have a look at the institutional rules and the expedited procedure. That's actually very, very popular with clients. A lot of our technology clients choose arbitration specifically because of the expedited procedure. As to whether it actually goes to it, actually, to be honest, there are very few that actually come down to an expedited procedure. That 6 months timeline never get tested, but at the outset there is that expectation that if we have a dispute, we'll resolve it really quickly, which is quite valuable.
Thanks. Well, I can end this discussion with sharing my experience that this provision of setting a timeline has been really very helpful as far as the arbitration that I've had for the domestic arbitrations. And I've noticed there has been a change in the mindset of the arbitrators as well, be it a member of a judicial background or a technical person. At least they drive the parties to finish it faster. And I do a lot of these construction-related matters where there are voluminous documents, and when you're forced to do something, then you find a way out. Okay, how do I capture all this information and how do I present it well? Then you start working under that pressure. And my experience has been that it has been quite beneficial. Yes, there are always cases where things still drag on. But with that, ladies and gentlemen, thank you so much. Well, at least I enjoyed moderating this session, and I hope you also had a good time. And if we have 5 minutes, no, please. Okay, 1 minute we have. If you have any questions for this panel, please feel free. 1 minute.
But everybody is here, I'm presuming good evening. I'm Shivang. I'm a third year law student at MNLU Mumbai. I had a question to Zal. Sir, you mentioned about the impediment of the third parties, and the case that Ms. Clara mentioned was regarding the Arupuri logistics. So sir, when you differentiated between section 9 and section 17, if we delve deeper into it, so when we talk about the civil procedure code under order 1 rule 10, we talk about the impediment of the parties. So the court ruled on the aspect saying that the court has the power. However, the civil court's the power that is conferred with the civil court cannot be conferred with the arbitral tribunal. So we talk about getting a statutory interpretation or clarity on that aspect. Then how do you think that the statute should clear on the aspect of the civil court's power being conferred to the court, however not to the tribunal?
I do think the important thing to bear in mind when we are talking about the court which grants the interim measure of protection under the Arbitration Act is to remember that it is not performing as a civil court. The concept of the civil court is a much wider concept where the court has a range of plenary powers to decide the issue. The arbitration court is just that. Actually, it is the court deciding, it is the court performing a specific statutory function as the arbitration court. So I think it would be a mistake to conflate the two concepts. But it is a mistake often made, I find, and in one sense, I mean, it is a mistake which has led us to the situation where we think that because it's the court that grants the relief, you can join third parties, but the tribunal can't. So, well, it's a very good question. I hope that's somewhat something of an answer, that we have to view the court differently when it sits as the arbitration court. Thank you for your question.